Lesson 8. Issue of Capital and Disclosure Requirements ICDR. Regulatory Framework 1. Regulatory Body. Governed primarily by SEBI. Issue of Capital and Disclosure Requirements Regulations, 2018 ICDR Regulations. 2. Purpose. To ensure transparency, investor protection, and fair practices in public issues. 3. Acts involved. Companies Act, 2013. SEBI Act, 1992. Securities Contracts Regulation Act, 1956. 4. Applicability. Applies to all companies issuing securities to the public. Equity, preference, debentures, etc. 5. Disclosure. Mandatory disclosure of material facts to enable informed investor decision-making. 6. SEBI Oversight. SEBI reviews draft offer documents and ensures compliance before approval. 7. Investor protection. Prevents misleading advertisements, insider trading, and price rigging. Example. When Zomato issued its IPO, it followed SEBI ICDR for eligibility, disclosures, and pricing norms. Introduction 1. Meaning. Issue of capital refers to raising funds from investors through securities. 2. Disclosure requirements. Companies must disclose true, accurate, and complete information. 3. Objective. Protect investor interests and maintain market integrity. 4. Types of offer. IPO, FPO, rights issue, preferential issue, QIP, etc. 5. Offer documents. Must comply with ICDR. Include prospectus, RHP, and other disclosures. Example. A company raising 500 crore rupees via IPO must file a draft offer document with SEBI. Types of issues. 1. Public issue. Offer of securities to the public through a prospectus. Includes IPO and FPO. 2. Rights issue. Offered to existing shareholders in proportion to their holdings. 3. Bonus issue. Free shares issued to existing shareholders. 4. Preferential issue. Issued to a select group of investors, not the public. 5. Qualified institutional placement QIP. Offer only to qualified institutional buyers QIBs. 6. Private placement. Offer to less than 200 investors, not considered public issue. 7. SME issue. For small and medium enterprises under special platform rules. Example. Infosys IPO public issue, HDFC Bank QIP institutional issue, TCS bonus issue. Meaning of draft offer document, letter of offer, and red herring prospectus. 1. Draft offer document DOD. Preliminary version of the prospectus. Filed with SEBI for observations before the final offer document is issued. Public comments invited for 21 days on SEBI's website. 2. Offer document. Final document after SEBI approval. Contains all disclosures, risk factors, financials, promoters, etc. 3. Red herring prospectus RHP. Preliminary prospectus filed before price determination. Price band is mentioned, but the exact price is fixed later. Used in book building process. Example. LIC IPO used in RHP with a price band of 902 rupees. 949 rupees per share. SEBI Issue of Capital and Disclosure Requirements Regulations, 2018 Genesis. 1. Introduced to replace 2009 ICDR Regulations. 2. Effective from September 11, 2018. 3. Aim. Simplify compliance and align with global standards. 4. Applies to all issues and listings of securities. Applicability Reg. 3. 1. Applies to IPO, FPO, rights issue, bonus issue, preferential issue, QIP. 2. Applies to both listed and unlisted public companies. 3. Does not apply to private placements or rights issue less than 10 crore rupees unlisted companies. Initial public offer IPO, further public offer FPO. Small diamond eligibility requirements for IPO Reg. 6.1 and 6.2.1. Net tangible assets is greater than or equal to 3 crore rupees in preceding 3 years. 2. Average operating profit is greater than or equal to 15 crore rupees in 3 years. 3. Net worth is greater than or equal to 1 crore rupees in each of 3 preceding years. 4. No willful default or winding up proceedings. 5. Project appraisal by financial institutions for project-based IPOs. 6. Dematerialization of shares mandatory before issue. 7. At least 1,000 shareholders after the issue for broad-based ownership. Example. A tech startup must show profitability or meet alternate route. Via QIB participation 75% book built. Entities not eligible to make IPO Reg. 5.1 and 2.1. Company in default of listing filing requirements. 2. Company whose promoters are debarred by SEBI. 3. Company with winding up orders pending. 4. Company with partly paid up shares. 5. Company not compliant with Companies Act SEBI. General conditions Reg. 7.1. In principle approval from stock exchanges before issue. 2. Minimum promoters, contribution as per regulation. 3. Lock-in on promoters' shares post-issue. 4. Daymot form only. 5. Use of proceeds disclosed clearly. 6. No misleading statements in advertisements. Additional conditions for offer for sale Reg. 8.1. Existing shareholders, promoters or others sell shares to the public. 2. Shares must be fully paid up. 3. Shares must be held for at least 1 year before the offer. 4. Minimum public shareholding norms apply 25%. Minimum public shareholding norms apply 25%. Example. Government disinvestment in Coal India Limited. Via offer for sale. Issue of warrants Reg. 13.1. Warrants equals option to buy shares at a later date. 2. Convertible within 18 months. 3. Minimum 25% of consideration payable upfront. 4. Balance paid at time of conversion. 5. Non-transferable. Further public offer FPO eligibility Reg. 103. 104.1. Company already listed on recognized stock exchange. 2. No pending listing or penalty from SEBI. 3. All shareholding in Daymot form. 4. Audit qualifications resolved. 5. Proceeds used only for disclosed purposes. Promoters, contribution. IPO. Minimum 20% of post-issue capital by promoters. FPO. Promoters may participate, but contribution capped by SEBI norms. Lock-in period. 3 years promoter, 1 year others. Lock-in requirements Reg. 16, 17, 115.1. Promoters, shares. Locked for 3 years from allotment. 2. Non-promoters. 1 year lock-in. 3. Exceptions. ESOPs, depository receipts, etc. Appointment of intermediaries 1. Lead manager, SEBI registered merchant banker. 2. Registrar to issue, maintains investor records. 3. Underwriters, guarantee subscription. 4. Compliance officer, ensures legal compliance. Fast track FPO Reg. 155-1. Listed for at least 3 years. 2. Average market cap of public shareholding is greater than or equal to 10,000 crore rupees. 3. No pending SEBI action. 4. No default in investor grievance redressal. 5. No need to file draft offer with SEBI. Example, Reliance Industries FPO used fast track route. Rights issue. Small diamond definition Reg. 61 offer of shares to existing shareholders in proportion to their existing holdings. Small diamond general conditions Reg. 62-1. Shares must be fully paid up. 2. Record date fixed. 3. Rights renounceable or non-renounceable. 4. Must file letter of offer with SEBI. Example, Infosys 1. 1 rights issue. Shareholders offered 1 share for every 1 held. Preferential issue Reg. 159, 161. Issue of securities to a select group of investors. 2. Must be authorized by special resolution. 3. Price not less than average of weekly high low for 26 weeks. 4. Lock-in. 3 years for promoters, 1 year for others. 5. Valuation by registered valuer mandatory. Example, Adani Enterprises issued preferential shares to an institutional investor. Qualified institutions placement QIP Reg. 172-1. Private placement to qualified institutional buyers QIBs. 2. Minimum 10 QIBs if issue greater than 250 crore rupees. 3. No need for SEBI or shareholder approval if within limits. 4. Purpose. Faster fundraising for listed companies. Example, HDFC Bank raised 4,000 crore rupees via QIP. Indian Depository Receipts IDRs Reg. 183, 213-1. Allows foreign companies to raise funds in India. 2. IDRs are Indian equivalents of ADRs GDRs. 3. Eligibility. Must have 3 years profitability. 4. Rights issue of IDRs allowed subject to SEBI norms. Example, Standard Chartered Bank issued IDRs in India. SME IPO Reg. 228, 231. For companies with post-issue paid-up capital is less than or equal to 25 crore rupees. 2. Listed on SME exchanges NSE Emerge, BSE SME. 3. Simplified compliance and disclosure. 4. Migration to main board allowed after 2 years and 10 crore rupees paid-up capital. Innovators Growth Platform IGP Reg. 251-1. For startups and technology-driven companies. 2. Minimum net worth not required. 3. At least 25% of pre-issue capital held by qualified investors. 4. Provides easier listing norms for innovation-based firms. Example, a health tech startup listing on IGP platform. Bonus issue Reg. 293, 295-1. Definition. Issue of free shares to existing shareholders out of reserves. 2. Conditions. Authorized by Articles of Association. Approved by board and shareholders. Reserves used must be free reserves. 3. Restrictions. No default in deposits of statutory dues. No partly paid up shares outstanding. 4. Completion. Within 15 days of board approval or 2 months of shareholders' approval if required. Example, TCS announced a 1 bonus issue. Additional important points for CS exam. Always mention relevant regulation number SEBI ICDR, 2018. Understand difference between draft offer document, and RHP. These are favorite exam questions. No lock-in periods and promoters, contribution precisely. Memorize eligibility norms for IPO, FPO, and fast track FPO. SEBI's main goal equals investor protection, transparency, fair disclosure, and capital market integrity. Perfect. This is lesson 9. Share-based employee benefits and sweat equity, another core and frequently tested chapter in capital market and securities law CS executive professional. Below is a complete, exam-oriented explanation, with 10 key points per subheading, concept clarity, and examples, strictly following the SEBI share-based employee benefits and sweat equity regulations, 2021 SEBI SBEB and SE regulations, 2021. Lesson 9. Share-based employee benefits and sweat equity. Regulatory Framework 1. Governing Regulation. SEBI Share-based Employee Benefits and Sweat Equity Regulations, 2021. Notified on August 13, 2021. 2. Objective. To consolidate 2 earlier sets of regulations. SEBI Share-based Employee Benefits Regulations, 2014, and SEBI Issue of Sweat Equity Regulations, 2002. 3. Authority. SEBI ensures transparency, fair valuation, and proper employee benefit management. 4. Applicability. For all listed companies that issue shares or share-linked instruments to employees. 5. Purpose. To motivate, retain, and reward employees by giving them ownership or profit-linked benefits. 6. Corporate governance link. Requires shareholder approval, audit oversight, and fair disclosure. Example, Infosys ESOPs were governed under these SEBI regulations, granting employees the right to buy company shares at a fixed price. Introduction 1. Share-based benefits equals non-cash incentives given in the form of company shares or options. 2. Encourage employee participation in company growth. 3. Aligns employee interests with those of shareholders. 4. Improves retention and performance. 5. Covers ESOS, ESPS, SAR, GEBS, RBS, and sweat equity. SEBI Share-based Employee Benefits and Sweat Equity Regulations, 2021 1. Came into effect August 13, 2021. 2. Merged regulations for uniformity and simplification. 3. Divided into 5 chapters. Chapter 1. Preliminary. Chapter 2. General provisions. Chapter 3. Specific schemes. Chapter 4. Sweat equity shares. Chapter 5. Miscellaneous 4. Applies to all listed companies issuing employee benefit shares or sweat equity. 5. Ensures fair valuation, disclosure, lock-in, and compliance. Applicability 1. Applies to listed companies issuing shares, options, or rights to employees. 2. Includes schemes implemented directly or through a trust. 3. Applies to subsidiary and associate companies if the listed company extends the scheme to them. 4. Non-applicable to unlisted or private companies. They follow Companies Act, 2013 provisions only. 5. Also applies to sweat equity issued by listed companies. Companies covered 1. All listed public companies on any recognized stock exchange. 2. May extend benefits to employees of the company, employees of its subsidiaries Indian or foreign, employees of associate companies. 3. Trusts formed for implementing ASOP ESPS are also covered. Example, TCS and its foreign subsidiary employees can be covered under one ASOP plan. Important definitions 1. Employee. Includes permanent employees, directors excluding independent directors of the company, subsidiaries, and associates. 2. Stock option. A right not obligation to buy shares at a predetermined price after vesting. 3. Vesting. Period after which an employee can exercise the option. 4. Exercise price. Price payable by the employee to buy shares. 5. Grant date. Date of issuing the option. 6. Exercise period. Time window during which the employee can convert options into shares. 7. Sweat equity shares. Shares issued to employees directors for know-how, intellectual property, or value addition instead of cash. 8. Trust. A separate entity formed to implement the scheme and hold shares on behalf of employees. Example. An IT engineer creating a patented algorithm for Infosys may receive sweat equity shares. Schemes. Implementation and process. Direct route 1. Company itself issues shares options directly to employees. 2. Shares allotted from fresh issue or secondary acquisition. 3. Company maintains an ASOP register. 4. No need to form a trust. 5. Easier for smaller companies or simpler schemes. Example. A company issues 10,000 ESOPs directly to senior developers. Implementation of schemes through Trust 1. Trust is a separate legal entity formed under the Indian Trusts Act, 1882. 2. Can acquire shares via secondary market purchases or fresh allotment from company. 3. Trust administers and transfers shares to employees upon vesting exercise. 4. Company provides loan or funds to the trust for share purchase. 5. Ensures independence and professional administration of ESOPs. Example. Infosys Employee Welfare Trust handles all ESOP-related transactions. Eligibility criteria 1. Permanent employees and directors of company, subsidiaries, or associates. 2. Independent directors and promoters excluded. 3. Employees on probation may be included if scheme provides. 4. Employee must contribute value addition or performance to be eligible. 5. Schemes may set minimum service period vesting condition. Compensation Committee 1. Constituted by the Board. Typically Nomination and Remuneration Committee NRC. 2. Minimum 3 directors, majority independent. 3. Responsible for designing and approving scheme, setting eligibility and vesting criteria, determining pricing formula, administering modifications. 4. Ensures scheme aligns with company goals and governance. Example. NRC approves the number of ESOPs to be granted annually. Shareholders approval 1. Mandatory by special resolution before implementing any scheme. 2. Separate resolution for each scheme. 3. Must disclose total number of shares, eligibility, pricing, lock-in, method of implementation. 4. For trust route, shareholder approval for secondary acquisition also needed. 5. Resolution valid till scheme duration unless modified. Variation of terms of the schemes 1. Company may vary or amend scheme terms by special resolution. 2. No variation affecting vested rights of employees. 3. Disclosure of revised terms to stock exchange and SEBI. 4. Examples. Change in vesting schedule, pricing formula, or trust mechanism. Winding up of the schemes 1. Allowed when scheme objectives achieved or company discontinues due to reorganization or merger. 2. Remaining shares disposed of as per SEBI guidelines. 3. Employees' vested rights protected. Non-transferability 1. Options, rights, or benefits cannot be transferred, pledged, or hypothecated. 2. Only the employee can exercise the option. 3. Exception. Transfer to legal heirs upon death or permanent incapacity. Listing 1. Shares issued under schemes must be listed on the same stock exchange. 2. Company must comply with SEBI LODR regulations, 2015. 3. Ensure DEMA form and ISIN-based identification for such shares. Certificate from auditors 1. Mandatory certificate from statutory auditors confirming compliance with SEBI SBEB regulations. 2. Must be placed before shareholders in the annual general meeting. 3. Filed with stock exchange. Disclosures 1. Board's report. Detailed scheme-wise disclosure annually. 2. Website disclosure. Summary of scheme uploaded. 3. Stock exchange disclosure. On grant, exercise, lapse, and total outstanding options. 4. Transparency to investors and regulators. Administration of specific schemes. Employee stock option scheme SOS 1. Grants options to employees to purchase shares at a predetermined price. 2. Minimum 1-year vesting period. 3. Exercise price determined by compensation committee. 4. No cash outflow until exercise. 5. Benefits employee retention and performance. 6. Shares allotted upon exercise of options. Example. Employee gets right to buy shares at 200 rupees after 1 year when market price is 350 rupees. Employee stock purchase scheme ESPS 1. Company offers shares at concessional price directly to employees. 2. Shares issued immediately, not options. 3. May have lock-in period, typically 1 year. 4. Usually used for broad-based employee participation. Example. Company offers 100 rupees shares to employees at 80 rupees. Stock appreciation rights SAR scheme 1. Employee receives monetary benefit equivalent to stock price appreciation. 2. No actual share allotment. 3. Cash settled SAR. Paid in money. 4. Equity settled SAR. Settled by giving shares. 5. Vesting period and performance criteria apply. Example. SAR of 100 rupees granted at 200 rupees share. Market price 300 rupees, right pointing arrow, 100 rupees gain to employee. General Employee Benefits Scheme GEBS 1. Scheme for providing benefits other than stock options. 2. Includes housing loan, education, medical, or insurance benefits funded via shares. 3. Implemented through a trust. 4. Trust may acquire shares for employee welfare. Retirement Benefit Scheme RBS 1. Special category for post-retirement benefits using company shares. 2. Shares can be purchased and held in trust until employee's retirement. 3. May provide financial security post-retirement. Issue of sweat equity by a listed company. Chapter 4. Introduction 1. Sweat equity equals shares issued to employees directors for intellectual property, know-how, or value addition. 2. Issued at discount or for non-cash consideration. 3. Used to reward key contributors. Applicability 1. Applies to listed companies only. 2. Regulated by Chapter 4 of SEBI SBEB and SE Regulations, 2021. 3. Also must comply with Section 54 of the Companies Act, 2013. Definition of employee includes permanent employee, director including whole-time or part-time, employee director of subsidiary or associate. Excludes independent director, promoter, and their relatives. Issue of sweat equity shares to employees 1. Can be issued for value addition or intellectual property. 2. Needs special resolution approval. 3. Subject to valuation and pricing norms. Example. A software engineer developing a patented system rewarded with sweat equity. Maximum quantum 1. 15% of existing paid-up equity capital in a year or 5 crore rupees, whichever is higher. 2. Total limit. 25% of paid-up capital at any time. 3. For startups less than 10 years old. Up to 50% in 10 years from incorporation. Special Resolution 1. Required prior to issuance. 2. Valid for 12 months. 3. Must mention number of shares, current price, consideration, recipients, details, pricing of sweat equity shares. 1. Determined by registered valuer based on fair value. 2. Price must reflect actual contribution value addition. 3. Can be issued at discount or for non-cash consideration. Valuation 1. Conducted by independent registered valuer. 2. Must value, intellectual property or know-how, and equity shares issued. 3. Both valuations recorded in board minutes. Accounting treatment. 1. Recorded as non-cash expense under employee compensation cost. 2. Debit. Employee benefit expense. Credit. Share capital share premium. Auditor certificate before AGM. 1. Statutory auditors must certify compliance with SEBI and Companies Act. 2. Certificate tabled at the annual general meeting. Ceiling on managerial remuneration. 1. Sweat equity to directors counts toward managerial remuneration ceiling as per section 197 of Companies Act. 2. Prior approval required if exceeding limits. Lock-in of sweat equity shares. 1. Minimum 3-year lock-in from date of allotment. 2. Ensures commitment of recipient to company's growth. Listing. 1. Shares must be listed on recognized stock exchanges. 2. Company must file details with stock exchanges immediately. Applicability of SEBI SAST regulations, 2011. 1. Sweat equity shares included in total shareholding. 2. If shareholding crosses 25% or triggers 5% increase, open offer obligations apply under SEBI Takeover Code. General obligations. 1. Proper disclosures in board's report and financial statements. 2. Maintain register of employee benefit schemes. 3. Timely filings with stock exchanges. 4. Compliance certificate from auditors annually. Exam quick tips. Sweat equity versus ASOP equals non-cash reward versus right to purchase. Know all vesting, pricing, and lock-in rules. Special resolution is mandatory for SOs, ESPS, and sweat equity. Valuation and auditor certificate are high probability CS exam questions. Lesson 10. Issue and listing of non-convertible securities. 1. Regulatory framework page 276 key points. 1. Governed by SEBI issue and listing of non-convertible securities regulations, 2021 NCS regulations. 2. Came into force on the 16th August 2021, replacing SEBI issue and listing of debt securities regulations 2008. 3. Regulates public issue, private placement, and listing of non-convertible debentures NCDs. Non-convertible redeemable preference shares NCRPS. Commercial papers CPs. 4. Also covers perpetual debt instruments PDIs and perpetual non-cumulative preference shares PNCPS. 5. Aim, to ensure transparency, investor protection, and uniformity in issuance and listing norms. 6. Issuers must comply with Companies Act, 2013, SEBI regulations, and stock exchange listing norms. 7. SEBI ensures that all issuances follow disclosure-based regulation DBR. Example, if Tata Motors issues 500 crore rupees worth of NCDs to the public, it must comply with SEBI NCS regulations, file offer documents, obtain credit rating, and list those NCDs. 2. Introduction page 276 key points. 1. Non-convertible securities NCS are instruments that cannot be converted into shares. 2. These include debentures, bonds, fixed income, non-convertible redeemable preference shares, perpetual instruments no maturity. 3. Companies use NCS to raise long-term funds without diluting equity. 4. NCS investors are creditors, not owners. 5. Interest or dividend is fixed and payable periodically. 6. Listing ensures liquidity and investor confidence. 7. Regulated by both SEBI and RBI for financial entities. Example, Infosys issues listed NCDs with 8% annual interest and 5-year tenure. Right pointing arrow. Investors earn interest, not equity. 3. Important definitions page 278 key points. 1. Debt securities, non-convertible instruments acknowledging debt obligation. 2. Issuer, company issuing the NCS. 3. Debenture trustee, entity monitoring issuer compliance and protecting investor interests. 4. Private placement, offer made to as less than or equal to 200 persons in a financial year, not a public issue. 5. In principle approval, preliminary nod from stock exchange before listing. 6. Credit rating, evaluation by SEBI registered CRA about repayment capability. 7. Lead manager, merchant banker handling public issue process. 8. Listing agreement, contract between issuer and stock exchange governing disclosure. 9. Recovery expense fund, fund to cover recovery costs in case of default. 10. ISIN, unique identification number for each security issue. 4. Applicability regulation 3 page 279 key points. 1. Applies to issuance and listing of all NCS by Indian companies. 2. Includes public issue of debt securities, public issue of NCRPS, private placement of NCS, listing of already issued securities. 3. Excludes convertible securities, sovereign government securities. 4. Applies to both listed and unlisted issuers when they seek listing. 5. General conditions and eligibility criteria chapter 2 page 279 key points. 1. Issuer must comply with Companies Act, 2013 and SEBI Act, 1992. 2. Must have in principle approval from stock exchange. 3. Credit rating mandatory. 4. Must appoint debenture trustee, registrar, lead merchant banker. 5. Debentures must be in DEMA form. 6. Must create recovery expense fund with designated stock exchange. 7. Listing fees payable to exchange. 8. Issuer must not be willful defaulter or ineligible under SEBI Act. 9. Trust deed must be executed before issue opens. Applicability of chapter regulation 4. Applies to both public issue and private placement. Issuer must fulfill all general conditions before filing offer document. Be eligible issuers regulation 5. Any company listed or unlisted, meeting net worth and compliance conditions. Not eligible. Companies declared willful defaulters, under winding up, are suspended by SEBI. C. In principle approval regulation 6. Must obtain approval from designated stock exchange before public issue opening. D. Depositories regulation 7. All NCS must be issued in dematerialized form via NSDL/CDSL. E. Debenture trustee regulation 8. Must be registered with SEBI. Protects debenture holders' rights and ensures issuer compliance. F. Registrar to the issue regulation 9. Handles investor applications, allotment, refunds, and record maintenance. G. Credit rating regulation 10. At least one SEBI registered CRA rating required. Must be disclosed in offer document. H. Recovery expense fund regulation 11. Maintained by issuer to cover expenses if debenture trustee needs to recover defaulted dues. I. Electronic issuances regulation 12. SEBI encourages online bidding, allotment, and payment via digital systems. J. Regulatory fees regulation 13. Issuer must pay SEBI fees as notified, usually a small percentage of issue size. K. Right to recall or redeem prior to maturity Reg. 15. Permitted if disclosed upfront and approved by debenture holders. L. Debenture redemption reserve Reg. 16. Companies must create DRR/CRR as per company's share capital and debentures rules, 2014. MISIN Reg. 17. Mandatory for identification and trading purposes. N. Trust deed Reg. 18. Executed between issuer and trustee. Defines rights, covenants, and obligations. O. Listing agreement Reg. 19. Issuer agrees to comply with SEBI's continuous disclosure and governance norms. P. Continuous listing conditions Reg. 20. Must disclose material events, financials, and credit rating revisions. Q. Trading of NCS Reg. 21. Only in DEMA form, through recognized exchanges or electronic platforms. R. Distribution of dividend in case of default Reg. 22. If default and interest redemption right pointing arrow no dividend or bonus shares can be issued. S. Obligations of issuer Reg. 23. Ensure payment, disclosure, and investor grievance redressal. T. Obligations of debenture trustee Reg. 24. Monitor asset cover, repayment, and compliance. Represent investors legally if default occurs. 6. Public issue and listing of debt securities NCRPS Chapter 3 Key Points. 1. File draft offer document DoD with SEBI and Stock Exchange. 2. Obtain in principle listing approval before issue. 3. Appoint lead manager, legal advisors, and trustee. 4. Minimum subscription level must be specified, usually 75%. 5. Allotment and refund must be completed within prescribed period. 6. Listing to be done within 6 working days of issue closure. 7. SEBI may review or return documents with comments. 7. Filing of draft offer document page 285 Key points. 1. DoD filed with SEBI and Stock Exchange before public issue. 2. Must contain full disclosures. Financials, purpose, risk factors, covenants. 3. SEBI reviews and provides observations. 4. Final offer document filed with ROC and Stock Exchange. 5. Must comply with SEBI LODR regulations, 2015 for post-issue disclosures. 8. Other obligations of the lead manager page 287 Key points. 1. Ensure accuracy and completeness of disclosures. 2. Coordinate with SEBI, issuer, trustee, and exchange. 3. Conduct due diligence on project, credit rating, and company performance. 4. Certify compliance before allotment. 9. Due diligence by debenture trustee page 287 Key points. 1. Verify security creation and charge registration. 2. Ensure issuer's ability to service debt. 3. Provide due diligence certificate to SEBI Stock Exchange before issue opens. 10. Listing of private placement of debt securities NCRPS Chapter 4 Key points. 1. Private placement can also be listed post-allotment. 2. Listing application to be filed with Stock Exchange within 4 days of allotment. 3. Issuer must submit placement memorandum and disclosure documents. 4. Credit rating and DEMA form mandatory. 11. Issuance and listing of perpetual debt instruments in PNSPS Chapter 5 Key points. 1. Used by banks and financial institutions for Tier 1 capital. 2. No fixed maturity period. Perpetual in nature. 3. Interest dividend may be non-cumulative. 4. Requires RBI approval for banks. 5. Disclosure of redemption, call, and loss absorption features. 12. Issuance and listing of NCS on private placement basis Chapter VA Key points. 1. Simplified process. No SEBI observation needed. 2. Issue through electronic book provider EBP platform for transparency. 3. Debenture trustee and credit rating mandatory. 4. Listing must be sought within prescribed time post-allotment. 13. Listing of commercial paper Chapter 6 Key points. 1. Short-term debt instrument is less than or equal to 365 days maturity. 2. Issued by corporates, FIS, or NBFCs. 3. Rating mandatory minimum A3 or equivalent. 4. Listed CPs offer tradability and transparency. 5. Disclosure and reporting norms similar to NCDs. 14. Role of a company secretary. Final topic Key points. 1. Ensure compliance with SEBI NCS regulations, 2021. 2. Maintain statutory records, filings, and liaison with SEBI Stock Exchange. 3. Assist in drafting offer documents and obtaining approvals. 4. Certify corporate governance and disclosure compliance. 5. Coordinate with debenture trustee and registrar. 6. Handle investor grievances and ensure redressal. 7. Advise board on regulatory and listing requirements. Extra for exam. Important regulation numbers. 4 to 24. Very high weightage. Distinguish. Public issue versus private placement. Case example. Reliance Industries 2021 NCD issue 10,000 crore rupees, SEBI NCS compliant. Key focus areas for CS exam. Credit rating. Debenture trustee's role. Recovery expense fund. Continuous listing conditions. Trustee and ISIN. Lesson 11. Listing obligations and disclosure requirements Lauder. 1. Regulatory framework page 294 Key points. 1. SEBI introduced LODR regulations, 2015, effective from December 1, 2015. 2. They consolidate the corporate governance and disclosure requirements under one regulation. 3. Objective. Ensure transparency, investor protection, and accountability of listed entities. 4. Applies to companies listed on recognized Indian stock exchanges NSE, BSE. 5. LODR replaced the old listing agreement system. 6. Provides both principle-based and rule-based obligations. 7. Divided into chapters, each for different securities shares, NCDs, NCRPS, etc. 8. Non-compliance attracts penalties under SEBI Act and Securities Contracts Regulation Act. Example. Infosys Limited. Listed on NSE and BSE, must comply with quarterly financial disclosures and related party transaction rules under SEBI LODR. 2. SEBI Listing Obligations and Disclosure Requirements Regulations, 2015 page 294 Key points. 1. Comprehensive Code for Disclosure, Governance, and Listing Obligations. 2. Covers corporate governance, related party transactions, periodic disclosures, event-based disclosures, responsibilities of directors and compliance officers. 3. Applicable to equity-listed companies, debt-listed companies, mutual funds for units, depository receipts. 4. Companies must also follow Companies Act, 2013 and SEBI circulars. 5. Divided into 9 chapters and 5 schedules. 3. Applicability page 294 Key points. 1. Applies to all listed entities. Those with listed equity shares, listed NCDs and CRPS, listed commercial papers. 2. Specific chapters apply to each security type. Chapter 4 right pointing arrow equity shares. Chapter 5 right pointing arrow NCS. 3. Foreign companies with Indian listings must also comply. 4. Applies from the date of listing approval by the stock exchange. 4. In principal approval page 294 key points. 1. Before listing securities, the issuer must obtain in principal approval from the stock exchange. 2. This ensures securities are eligible for listing. Issuer meets all requirements under SEBI and exchange norms. 3. Valid for a specified time, usually 3 months. 4. After allotment, final listing and trading approval are obtained. 5. Prevents irregular or fraudulent issues. Example, before IPO, Zomato obtained in principal approval from both NSE and BSE under Regulation 28. 5. Key definitions page 295 important terms. 1. Listed entity. Any company whose securities are listed on a recognized stock exchange. 2. Promoter group. Controls or manages the company. 3. Subsidiary. Defined as per Companies Act, 2013. 4. Related party. As per Regulation 21ZB, includes promoters, directors, key managerial personnel, relatives, and their entities. 5. Material subsidiary. Subsidiary with greater than 10% of consolidated income net worth. 6. Control. Right to appoint majority directors or control policy decisions. 7. Quarter. Defined for reporting purposes as per financial calendar. 6. Obligations of listed entities page 297 key points. 1. Must ensure fair, timely, and accurate disclosure to investors. 2. Must maintain a functional website disclosing financials, annual reports, and policies. 3. Appoint compliance officer responsible for SEBI and exchange compliance. 4. Follow code of conduct for board and senior management. 5. Submit certificates and periodic reports to stock exchanges. 6. Ensure grievance redressal via SCOR's SEBI's platform. 7. Common obligations of listed entities page 298 key points. 1. Timely submission of financial results quarterly and yearly. 2. Disclosure of shareholding pattern, corporate governance report. 3. Redress investor grievances within 21 days. 4. Disclosure of defaults or rating downgrades. 5. Company secretary acts as compliance officer. 6. Maintain at least one functional email ID for investor complaints. 8. General obligations applicable to all listed companies page 298 key points. 1. Listed companies must ensure board oversight of compliance. 2. Provide quarterly compliance certificates. 3. Disclose changes in capital structure, management, or shareholding. 4. Ensure dematerialized form of securities. 5. File annual report and financial statements on time. 6. Notify exchanges about material events as per Regulation 30. 7. Avoid misleading or selective disclosures. Corporate governance under SEBI Law Regulations, 2015. 9. Composition of Board of Directors Reg. 17 page 299 key points. 1. Optimum mix of executive, non-executive, and independent directors. 2. Minimum 50% non-executive directors. 3. If chairman is executive, right pointing arrow is greater than or equal to 50% independent directors. 4. If chairman is non-executive, right pointing arrow is greater than or equal to 1/3 independent directors. 5. At least one woman director. 6. Board must meet at least 4 times a year, max 120 days gap. 7. Audit, nomination, risk, and stakeholders committees are mandatory. Example, Infosys has 12 directors, right pointing arrow 7 independent, 3 executive, 2 non-executive equals compliant. 10. Minimum directors requirement page 300. Public company, right pointing arrow 3 directors minimum. Private, right pointing arrow 2 directors. Board strength depends on business scale. 11. Maximum age of non-executive directors page 300. If greater than 75 years, appointment reappointment needs special resolution and AGM with justification. 12. Shareholders approval for appointment as director manager page 300. Must be approved by shareholders in general meeting. Appointment of independent director, right pointing arrow special notice and consent required. 13. Vacancy in the office of director page 300. Vacancy must be filled at next board meeting or within 3 months, whichever is later. 14. Meetings of board page 301. Minimum 4 board meetings per year. Gap between 2 meetings is less than or equal to 120 days. 1 meeting per quarter mandatory. 15. Quorum of board meeting page 301. 1/3 of total strength or 3 directors, whichever is higher. 16. Board committees page 301. 306 key committees. 1. Audit committee reg. 18. Minimum 3 directors, right pointing arrow 2 3 independent. Chairperson, right pointing arrow independent. Role. Review financials, audit reports, internal control. 2. Nomination and remuneration committee reg. 19. Is greater than or equal to 3 directors, all non-executive. Is greater than or equal to 50% independent. Frames policy for appointment and remuneration. 3. Stakeholders relationship committee reg. 20. Resolves investor and security holder grievances. 4. Risk management committee reg. 21. For top 1,000 listed entities. Identifies, monitors, and mitigates risks. 17. Maximum number of directorships committee membership page 306 limits. 1. Max 7 listed companies as independent director. 2. Total 20 directorships, of which 10 can be public. 3. Chairmanship. Max 5 committees across all companies. 4. Ensures director efficiency and accountability. Related party transactions RPT. 18. Regulation 23. RPT page 307 key points. 1. Applies to transactions between company and its related parties. 2. Must be approved by audit committee. 3. Requires shareholders approval if material. 19. When is an RPT material? Page 309. Transaction exceeds 1,000 crore rupees or 10% of annual consolidated turnover, whichever lower. 20. Approval by audit committee page 309. All RPTs need prior approval. Committee reviews valuation, terms, and interest of related parties. 21. Approval of shareholders page 310. Ordinary resolution required. Related parties can't vote. 22. Exceptions page 310. Intergroup transactions between wholly owned subsidiaries exempt. Arm's length and ordinary course transactions exempt. Subsidiary governance and audit. 23. Corporate governance of subsidiary reg. 24 page 310. At least one independent director of parent on subsidiary board. Review financials of unlisted subsidiaries. Prior approval for disposal of significant assets. 24. Secretarial audit and compliance report reg. 24A page 311 key points. 1. Annual secretarial audit report by IPCs. 2. Also file secretarial compliance report within 60 days of FY end. 3. Applies to all listed entities and material unlisted subsidiaries. 25. Exceptions page 311. Certain small, listed debt-only companies may get exemptions from corporate governance provisions. Disclosures and shareholder rights. 26. Prior intimations Reg. 29 page 312. Prior notice to stock exchange before. Board meetings for financials. Dividend declaration. Fundraising plans. 27. Disclosure of events or information Reg. 30 page 312. Must disclose material events like resignation of directors, mergers, acquisitions, defaults or credit downgrades, to be disclosed within 24 hours. 28. Outcome of board meetings page 313. Board decisions like dividends, fundraising, buybacks right pointing arrow disclosed within 30 minutes. 29. Documents and information to shareholders Reg. 36 page 314. Circulate annual report, AGM notice, financial statements, auditors report to all shareholders electronically and physically. 30. Meetings of shareholders and voting Reg. 44 page 314. Voting via e-voting mandatory for all listed companies. Disclose results within 48 hours of meeting. 31. Policies and processes page 314. Listed companies must frame and disclose. Dividend distribution policy. RPT policy. Vigil mechanism whistleblower policy. Risk management policy. COMPLIANCES under Lauder. 32. One-time compliances page 315. Before listing, submit initial listing application, corporate governance structure, and declaration by directors. 33. Quarterly compliances page 316. Financial results Reg. 33. Shareholding pattern Reg. 31. Corporate governance report Reg. 27. Investor complaint status Reg. 13. 34. Half-yearly compliances page 317. Statement of asset cover for debt securities. Certificate of security cover by auditors. Related party transactions disclosure. 35. Yearly compliances page 317. Annual report submission. Secretarial compliance report Reg. 24A corporate governance certificate by PCs. 36. Event-based compliances page 318. Any material change right pointing arrow within 24 hours. Appointment resignation of directors. Change in auditors. M&A, demerger, or capital restructuring. 37. Regulations for top 500, 1,000, 2,000 entities page 320. Top 1,000 right pointing arrow risk management committee mandatory. Top 500 right pointing arrow business responsibility and sustainability report BRSR. Top 2,000 right pointing arrow enhanced disclosure and ESG reporting norms. 38. Compliances for listed entities with NCS page 321. Must file half-yearly financial results, asset cover, and default reports. Maintain debenture trustee coordination and recovery fund. 39. Liability of a listed entity for contravention page 323. SEBI may impose penalty under Sec. 15A of SEBI Act. Suspension or delisting. Freezing of promoter shareholding. 40. Role of company secretary page 323. 324 for CS in employment. 1. Act as compliance officer. 2. File periodic returns and disclosures. 3. Ensure corporate governance compliance. 4. Liaise with SEBI, exchanges, and trustees. For CS in practice. 1. Conduct secretarial audit under Reg. 24A. 2. Issue compliance certificates. 3. Advise clients on listing regulations and disclosures. Exam focus summary. Learn Reg. 17, 18, 19, 20, 21, 23, 24, 24A, 27, 30, 33 right pointing arrow most tested regulations. Always write timely disclosure, transparency, and governance as SEBI's objectives. Remember tables for compliance frequency and applicability top 500, 1000, 2000. Perfect. You're now on lesson 12. Acquisition of shares and takeovers. Concepts from capital market and securities law CS executive. Lesson 12. Acquisition of shares and takeovers. Concepts. 1. Regulatory framework page 331. The SEBI Substantial Acquisition of Shares and Takeovers Regulations, 2011 Takeover Code governs mergers, acquisitions, and control changes of listed Indian companies. 2. It replaced the earlier SEBI SAST regulations, 1997 to make the process more transparent and investor-friendly. 3. Objective. Protect small shareholders' interests when control of a listed company changes. 4. Based on recommendations of the Takeover Regulations Advisory Committee track chaired by Mr. C. Ashudan. 5. Empowered by Section 11(2)(h) of the SEBI Act, 1992. 6. Applies to acquisition of shares, voting rights, or control of a listed company. 7. SEBI ensures timely public offers, fair pricing, and information disclosure. 8. Violations are punishable under Section 15H of SEBI Act, penalty up to 25 crore rupees or 3x profit. Example. When Reliance Industries acquired control in Network 18, SEBI SAST rules were triggered, leading to a mandatory open offer. 2. Introduction page 331. A takeover occurs when an acquirer gains control of a target company by buying a substantial stake. 2. It may be friendly with management consent or hostile against management's will. 3. Takeovers promote efficiency, better management, and economic restructuring. 4. Can be through direct purchase from promoters, open market, or tender offer. 5. SEBI ensures minority shareholders are given an exit opportunity. 6. The open offer mechanism ensures acquirers pay fair value to public shareholders. 7. Typically triggered when shareholding crosses 25% threshold. Example. If Company A buys 26% of Company B's shares on the stock exchange, it must make an open offer to buy at least 26% more shares from public shareholders. 3. Genesis page 330. 331-1. Before SEBI, takeovers were governed by Companies Act, 1956 provisions on mergers. 2. In the 1990s, SEBI introduced SAST Regulations 1994, revised 1997, overhauled in 2011. 3. The 2011 regulations brought modern principles. Control, voluntary offers, disclosures. 4. India's takeover framework modeled partly on UK takeover code fairness, transparency. 5. Focused on protecting minority shareholders and ensuring market integrity. 6. Introduced indirect acquisition and persons acting in concert pact definitions. 4. SEBI Substantial Acquisition of Shares and Takeovers Regulations, 2011. A bird's eye view page 332-1. Divided into 7 chapters and 5 schedules. 2. Covers. Substantial acquisition of shares voting rights. Acquisition of control. Exemptions. Open offer process and disclosures. 3. Key thresholds. 25% trigger and 5% creeping acquisition. 4. Ensures fair exit to existing shareholders at determined offer price. 5. Provides SEBI the power to relax strict compliance in public interest. Example. An acquirer crossing 25% in a listed entity must make a public offer for 26% of total shares. 5. Important definitions page 332. 336-1. Acquirer Reg. 21A. Any person who acquires shares voting rights control. 2. Target company Reg. 21Z. Listed company whose shares are being acquired. 3. Persons acting in concert pact. Persons cooperating for a common acquisition objective. Example, a promoter group and its family members. 4. Control Reg. 21E. Right to appoint majority of directors or influence management policy decisions. Includes positive control decision power and negative control veto rights. 5. Open offer Reg. 210. Offer made by acquirer to public shareholders for purchasing shares. 6. Creeping acquisition. Gradual acquisition up to 5% per financial year after reaching 25%. 7. Indirect acquisition. When control is gained over an entity that holds shares in the target company. 6. Applicability and exception page 336-1. Applicable to acquisition of shares, voting rights, or control in a listed company. 2. Not applicable to interstate transfer among promoters Reg. 10. Acquisition pursuant to court-approved schemes. Acquisition under rights issue subject to conditions. Buyback of shares by the company. 3. Applicable to both direct and indirect acquisitions. 4. SEBI may grant exemption under Regulation 11 on application. 7. Trigger point for making an open offer by an acquirer page 337. A 25% shares or voting rights 1. When acquirer alone or with pact crosses 25% shareholding, open offer must be made. 2. Offer must be for at least 26% of total shares of the target company. 3. Ensures minority shareholders get exit at the same price. 4. Triggered even by indirect acquisitions. 5. SEBI must be intimated and public announcement made. Example, if an investor buys 27% of XYZ Limited, he must make an open offer for 26% additional shares. B. Creeping acquisition limit 1. After reaching 25%, acquirer may acquire up to 5% per financial year without open offer. 2. Acquisition beyond 5% in 1 year triggers open offer. 3. Helps acquirers gradually consolidate holdings. 4. Applies only if total holding does not exceed 75% maximum permissible limit. 8. Open offer page 338-1. Mechanism to provide exit opportunity to public shareholders. 2. Price must be determined as per Regulation 8 highest of multiple benchmarks. 3. Acquirer must appoint a merchant banker. 4. Open offer size, at least 26% of total shares. 5. Letter of offer filed with SEBI for comments. 6. Shareholders can tender shares within 10 working days from offer opening. 7. Acquirer must pay within 10 working days of closure. 8. SEBI monitors compliance strictly. 9. Mandatory open offer page 338. 342-1. Triggered on crossing 25% or acquiring control. 2. Offer price based on highest price paid by acquirer or market average. 3. Ensures no shareholder is left disadvantaged. 4. Process includes public announcement, detailed public statement, filing letter of offer, tendering period, payment to shareholders. 5. Withdrawal only allowed under exceptional SEBI-approved cases e.g. legal prohibition. 10. Voluntary offer page 342-1. Made by an acquirer already holding 25% or more but less than 75%. 2. Optional, unlike mandatory offer. 3. Offer must be for at least 10% of total shares. 4. No acquisition allowed during offer period except through the offer. 5. Cannot be withdrawn once made except by SEBI approval. 6. Promotes fairness and market transparency. 11. Key differences between compulsory and voluntary open offer page 343. Basis. Mandatory offer. Voluntary offer. Trigger. Statutory crossing 25% or control. Discretionary. Objective. Legal compliance. Increase holding. Minimum size. 26%. 10%. Withdrawal. Limited. Limited. SEBI approval. Mandatory. Required only if withdrawn. 12. Minimum offer size page 343-1. Minimum offer. 26% of the total share capital of the target company. 2. Ensures public shareholders have a fair exit. 3. Can be higher if acquirer desires. 4. Ensures transparency and investor protection. 13. Process at a glance page 344-1. Trigger event right pointing arrow 25% or control acquisition. 2. Public announcement by acquirer. 3. Detailed public statement within 5 working days. 4. Draft letter of offer filed with SEBI. 5. Tendering period. 10 working days. 6. Completion. Shares transferred. Payment made. 7. Post offer reporting to SEBI. 14. Disclosures page 345-1. Reg. 29. Acquisition or disposal of 5% or more right pointing arrow disclosed to stock exchanges within 2 working days. 2. Reg. 30. Continual disclosure by persons holding is greater than or equal to 25%. 3. Target company must disclose such acquisitions to stock exchanges. 4. Ensures market transparency and prevents insider information misuse. 5. SEBI monitors continuous disclosures. 15. Exemptions page 347 or Regulation 10. Automatic exemptions 1. Interstate transfer among promoters. 2. Acquisition through inheritance or gift. 3. Rights issue subject to proportional holding. 4. Acquisition under SEBI approved schemes e.g. mergers. 5. Increase due to buyback of shares by the company. B. Regulation 11. Exemption by SEBI 1. SEBI may grant exemption on application if in public interest. 2. Applicant must submit merchant banker certificate and justification. 3. SEBI may impose conditions e.g. lock-in. 4. Common and corporate restructuring, family settlements, or debt conversions. Additional notes for exam. Control test Reg. 2E equals key issue in several SEBI cases like Sucum Ventures vs. SEBI 2010. Pricing formula Reg. 8 equals highest of a negotiated price, B highest price in last 26 weeks, or C volume weighted average price. Pact disclosure crucial. Joint investors must be considered together. Penalty under SEBI Act Sec. 15H. Up to 25 crore rupees or thrice profit gained. Lesson 13. Prohibition of insider trading. 1. Regulatory framework page 361. Insider trading in India is regulated by SEBI Prohibition of Insider Trading Regulations, 2015. 2. Enforced under Section 11(2) grams and Section 12(a)(e) of the SEBI Act, 1992. 3. Objective. Prevent unfair advantage through access to unpublished price-sensitive information UPSI. 4. Applies to all persons associated with the company. Directors, employees, auditors, consultants, etc. 5. Ensures market transparency and investor confidence. 6. Non-compliance attracts civil and criminal penalties under SEBI Act, 1992 and the Companies Act, 2013. 7. SEBI has wide investigation and enforcement powers. 8. Based on global models like the U.S. SEC insider trading rules and UK market abuse regulation. 2. Introduction page 361. Insider trading means dealing in securities of a company based on confidential, price-sensitive information. 2. The unfair use of non-public information gives undue advantage to insiders. 3. It undermines investor trust and market integrity. 4. Example, a director buying shares before quarterly results are published knowing profits will surge. 5. The 2015 regulations replace the old 1992 regulations to align with global standards. 6. Key focus, prevention, monitoring, and deterrence. 7. Establishes codes of conduct and disclosure mechanisms. 3. Genesis page 361. Concept first recognized in U.S. Securities Exchange Act of 1934. 2. In India, early cases like Hindustan Lever Limited vs. SEBI 1998 triggered the need for clear law. 3. SEBI first issued PID regulations, 1992, which were later overhauled in 2015. 4. Based on recommendations of the N.K. Sodhi Committee 2013. 5. Goal, to simplify definitions, clarify gray areas, and introduce global best practices. 4. Committees recommending prohibition of insider trading page 360. 361-1. Justice P.N. Bhagwati Committee 1986. First recommended the need to curb insider trading. 2. Kumar Mangalam Birla Committee 1999. Highlighted insider trading as part of corporate governance. 3. N.K. Sodhi Committee 2013. Formed by SEBI to draft a new regulation framework basis of 2015 rules. 4. SEBI Primary Market Advisory Committee. Suggested inclusion of informant mechanism and stronger disclosure. 5. SEBI Board 2019. Approved amendments for whistleblower rewards and structured digital reporting. 5. SEBI Act, 1992 page 361-1. Section 12A prohibits insider trading directly. 2. Section 11 2 grams. SEBI empowered to regulate insider trading. 3. SEBI can investigate any person suspected of insider trading. Section 11C. 4. Section 15G. Provides penalties, up to 25 crore rupees or 3x profit gained, whichever higher. 5. SEBI can issue cease and desist orders or restrain trading. 6. Prosecution under Section 24 for willful violations, imprisonment up to 10 years. 6. SEBI Prohibition of Insider Trading Regulations, 2015. Regulatory Framework page 362-1. Introduced on January 15, 2015, replacing 1992 regulations. 2. Focuses on prohibition of communication dealing in UPSI, disclosures by insiders, codes of conduct and fair disclosure. 3. Introduced concept of trading plans for legitimate trades. 4. Added informant mechanism 2019 amendment. 5. Emphasized role of compliance officer and board oversight. 6. Strengthened accountability and whistleblower protection. 7. Key definitions page 362. 364. A compliance officer 1. Senior employee, typically the company secretary, designated by the board. 2. Responsible for ensuring compliance with PID regulations. 3. Maintains records of UPSI access, trading plans, pre-clearances. 4. Monitors trading window closures. 5. Reports to Board Audit Committee on insider compliance. 6. Plays a key role during financial result periods. Example, freezing trading window 48 hours before results. B. Insider Reg. 2G1. A person who is a connected person or possesses or has access to UPSI. 2. May include directors, employees, consultants, or relatives. 3. Example, company's finance head, who knows upcoming acquisition plans. C. Person deemed to be connected Reg. 2D1. Individuals associated with the company in any capacity during the preceding 6 months. 2. Includes merchant bankers, auditors, legal advisors, and consultants. 3. Presumed to have access to UPSI unless proven otherwise. D. Immediate relative 1. Spouse, parent, sibling, or child of insider. 2. Their trades are also considered insider trades if influenced by insider's knowledge. Example, director's spouse trading based on upcoming merger information. E. Proposed to be listed 1. Refers to unlisted companies that have filed a listing application. 2. Insider trading regulations apply to them from the time they plan a public issue. F. Informant 1. Whistleblower who reports insider trading violations to SEBI. 2. Protected under Regulation 7A. 7I 2019 Amendment. 3. Eligible for monetary reward up to 10 crore rupees. G. Trading Reg. 2L1. Includes subscribing, buying, selling, dealing, or agreeing to deal in securities. 2. Covers both physical and electronic transactions. 3. Example, exercising stock options or derivatives also counts as trading. H. Unpublished price-sensitive information UPSI Reg. 2N1. Any non-public information that, if published, may affect security prices. 2. Includes financial results, dividends, change in capital structure, mergers or acquisitions, changes in key management. 3. Becomes public once disclosed to the stock exchange. 8. Restriction on communication or procurement of UPSI Regulation 3 page 365. 366-1. No person shall communicate, provide, or allow access to UPSI unless required for legitimate purpose. 2. Legitimate purposes include due diligence, legal obligation, or professional duties. 3. Must be covered under a confidentiality agreement. 4. Board must define legitimate purposes in code of conduct. 5. Communication with an insider's e.g. legal advisor allowed if necessary. 6. Example, sharing UPSI with investment banker for M&A evaluation equals legitimate. 9. Trading when in possession of UPSI. Permission and limitation regulation 4 page 368. 373-1. No insider shall trade when in possession of UPSI. 2. Exceptions. Off-market inter-se promoter transfers. Trades under approved trading plans. Transactions under statutory regulatory obligations. 3. Burden of proof. On insider to show that trade was not based on UPSI. 4. Example, promoter transferring shares to spouse as part of family settlement. Exempt. 10. Trading plans regulation 5 page 373-1. Enables insiders to trade legitimately even when they may have UPSI. 2. Must be pre-approved by compliance officer. 3. Disclosed to stock exchange after approval. 4. Minimum 6 months cooling off period before trade begins. 5. Cannot overlap with any other trading plan. 6. No trading between closure of financial quarter and 48 hours after result disclosure. Example, CEO submits a 12-month plan to sell shares every quarter. Once approved, trades are legitimate even if he later possesses UPSI. 11. Disclosure requirements page 375. 377-1. Initial disclosure reg. 71A. Promoters, KMPs, directors disclose holdings on appointment. 2. Continual disclosure reg. 72. Changes exceeding 10 lakh rupees in value must be disclosed within 2 trading days. 3. Company must inform the stock exchange within 2 days of receipt. 4. Example, CFO buys shares worth 15 lakh rupees. Must disclose. 12. Informant incentives and rewards page 377. 378-1. Introduced by 2019 amendment. 2. Informants can submit details via Form A on SEBI portal. 3. SEBI may grant reward up to 10 crore rupees post successful recovery. 4. Identity remains confidential. 5. Protection against retaliation by employer. 6. Encourages whistleblowing and strengthens surveillance. 13. Codes of Fair Disclosure and Conduct Regulation 8 and 9 page 378. 381-1. Every listed company must have. Code of Fair Disclosure Reg. 8. For public dissemination of UPSI. Code of Conduct Reg. 9. For internal regulation and monitoring trades. 2. Code must be published on company's website. 3. Aim. Equal access to information by all investors. 4. Compliance officer enforces the code. 5. Periodic audits and training programs recommended. 14. Minimum standards for Code of Conduct page 381. 384-1. Regulation 9-1 specifies standards including identification and handling of UPSI, pre-clearance for trades by designated persons, trading window norms, record maintenance of access to UPSI, internal whistleblower procedures. 2. Violations to be reported to Audit Committee and SEBI. 15. Penalty provisions for violations page 384. 385-1. Section 15G of SEBI Act. Fine. 10 lakh rupees to 25 crore rupees or 3x profit gained, whichever higher. 2. Section 24. Imprisonment up to 10 years for willful default. 3. SEBI may confiscate illegal gains and ban trading for certain periods. 4. Companies Act, 2013 Section 195 also prohibits insider trading for unlisted cuz. 5. SEBI can issue cease and desist orders. Example, in Rakesh Agarwal vs. SEBI 2004, SEBI fined insider for trading based on unpublished merger info. 16. Appeal to Securities Appellate Tribunal SAT page 385-1. Aggrieved persons may appeal SEBI's order to SAT under Section 15T of SEBI Act. 2. Must file within 45 days of order. 3. SAT may confirm, modify, or set aside SEBI's decision. 4. Further appeal lies to Supreme Court under Section 15Z. 17. Role of Company Secretary as Compliance Officer page 385. 386-1. Usually designated as Compliance Officer under Regulation 2C. 2. Duties include monitoring UPSI and trading windows, maintaining insider list, approving trading plans and pre-clearances, ensuring timely disclosures, conducting training and awareness, reporting violations to SEBI. 18. Checklists under SEBI PIT Regulations, 2015. Maintain insider list names, PAN, role, define and disclose UPSI handling procedure, pre-clearance mechanism for trades above threshold, trading window closure during UPSI periods, disclose code of conduct on website, ensure board approval for amendments, record keeping for 5 years. Important exam tips. Always remember UPSI plus trade equals insider trading unless covered under exception. Define connected person, immediate relative, and UPSI clearly. 3 most tested areas. Revise Regulations 3, 4, 7, 8, and 9. The 5 pillars of PIT Regulations. Case laws. Hindustan Lever Limited vs. SEBI 1998. Rakesh Agarwal vs. SEBI 2004. Dilip Pence case. Classic example of insider dealing. Lesson 14. Prohibition of fraudulent and unfair trade practices relating to securities market FUTP. Regulatory Framework 1. The Securities and Exchange Board of India Prohibition of Fraudulent and Unfair Trade Practices Relating to Securities Market Regulations 2003. Issued under SEBI Act, 1992. 2. These regulations aim to maintain market integrity and investor confidence. 3. Prohibits acts of fraud, deception, market manipulation, and insider-like activities that mislead investors. 4. The regulatory framework is supported by Section 11, 11b, 11c, 12a of the SEBI Act, 1992. SEBI's powers to issue directions, conduct investigations, and penalize violators. 5. Ensures transparency and fairness in securities trading and market operations. 6. Protects investors from artificial price inflation, circular trading, misleading statements, etc. 7. Covers primary as well as secondary markets. Introduction 1. Fraudulent and unfair trade practices FUTP. Actions that mislead investors or distort market prices. 2. SEBI introduced PFUTP regulations, 2003 to combat such manipulations. 3. These regulations replace the 1995 regulations. 4. Core objective. Preserve market integrity and prevent manipulation. 5. Targets both individuals and intermediaries involved in unfair trading. 6. Emphasizes honest, transparent, and informed transactions. Example, circular trading to inflate share price of XYZ Limited. So investors buy at high price. This violates PFUTP. Genesis and background 1. Triggered by scams such as Harshad Mehta 1992 and Keaton Correct 2001. 2. These scams exposed loopholes in the market system. 3. SEBI gained statutory powers through amendments in SEBI Act, 1995. 4. Need for a comprehensive regulation addressing manipulation and fraud. 5. PFUTP Regulations 2003. Formulated to deter unfair market behavior and regain investor trust. SEBI Prohibition of Fraudulent and Unfair Trade Practices Relating to Securities Market Regulations, 2003-1. These regulations contain 12 key regulations divided into chapters. Chapter 1. Preliminary Definitions. Chapter 2. Prohibition of Unfair and Fraudulent Practices. Chapter 3. Investigation and Enforcement 2. They apply to all market participants. Brokers, analysts, investors, companies, etc. 3. Introduces a broad definition of fraud, including omission and misleading statements. 4. Provides SEBI power to investigate and penalize. Important definitions. Regulation 2.1. Fraud Reg. 2.1c. Any act, expression, omission, or concealment committed with intent to deceive. Includes false statements, misleading appearance, or concealment of material facts. Example, promoter announces fake merger news to inflate share price. 2. Dealing in securities, buying, selling, or otherwise transacting in securities. 3. Person, includes individuals, companies, firms, HUF, AOP, etc. 4. Securities, as defined in the Securities Contracts Regulation Act, 1956. 5. Stock exchange, any recognized stock exchange under the SCRA. 6. The definitions are wide and inclusive, ensuring even indirect manipulation is covered. Prohibition of Fraudulent and Unfair Trade Practices. General Objective 1. The core regulation prohibits all kinds of manipulative, deceptive, and unfair transactions. 2. Ensures free and fair price discovery. 3. Protects investors from false information and misleading advertisements. 4. Applies to both listed and unlisted companies intending to list securities. 5. Covers intermediaries, analysts, promoters, and companies alike. Prohibition of certain dealings in Securities Regulation 3.1. No person shall buy, sell, or deal in securities in a fraudulent manner. 2. Prohibits using manipulative or deceptive devices. Employing any scheme to defraud other persons. Engaging in acts likely to mislead investors. 3. Example. Broker spreads false news about company performance to trigger demand. Prohibition of manipulative, fraudulent, and unfair trade practices Regulation 4.1. Lists specific prohibited actions, such as creating artificial trading volumes e.g. circular or synchronized trades, spreading false or misleading information, price rigging to induce others to trade, using fake or front accounts for manipulative trades, insider-like timing of trades to affect price movements. 2. Example. Pump and dump schemes. Operators pump prices by false info and then dump shares. Investigation Chapter 3.1. SEBI may investigate any case of suspected fraud, manipulation, or unfair trade. 2. Investigation is a fact-finding exercise, not a criminal trial. 3. Based on complaints from investors, market surveillance alerts, news reports or whistleblower inputs. 4. SEBI may appoint an investigating authority. Power of SEBI to order investigation Regulation 5.1. SEBI can direct investigation if there are reasonable grounds to believe fraudulent acts have been committed. Transactions are being carried out to manipulate prices. 2. Reasons may include sudden price fluctuations, abnormal trading volume, insider trading signals. 3. SEBI issues written orders specifying scope and reasons. Powers of Investigating Authority Regulation 6.1. EMA. Demand production of books, documents, records. Examine brokers, directors, officers. Inspect bank accounts, trading accounts, communication records. 2. Can record statements under oath. 3. Has powers similar to civil court under CPC for summoning and document production. 4. Entities must comply. Non-cooperation invites penalties. Duty to cooperate Regulation 8.1. Every person under investigation must produce required documents, furnish necessary information, not destroy or tamper with evidence. 2. Failure attracts penalties under SEBI Act. 3. Promotes a culture of transparency and accountability. Submission of report to SEBI Regulation 9.1. After investigation, the EA submits a detailed report to SEBI. 2. Report includes findings of fact, evidence collected, recommendations for action. 3. SEBI may then initiate enforcement action or adjudication. Enforcement by SEBI Regulation 10 and 11.1. SEBI can issue directions e.g. suspend trading, restrain entities, initiate adjudication under Chapter V of SEBI Act, impose penalties, disgorgement, or prosecution. 2. Common directions include debarment from securities market, freezing of assets, ordering refund to investors. 3. Example. Sahara case. SEBI ordered refund of illegally raised money. Manner of service of summons and notices Regulation 11A1. SEBI must serve notices through registered post, speed post, email official address, publication in newspapers if address not traceable. 2. Ensures due process and fair hearing to the person charged. 3. Avoids cases of non-service delaying proceedings. Suspension or cancellation of registration Regulation 12.1. SEBI can suspend or cancel registration of brokers, sub-brokers, merchant bankers, portfolio managers, etc. 2. Grounds. Fraudulent activity, non-cooperation during investigation, violation of FUTP or SEBI Act. 3. Objective. Discipline intermediaries and preserve market integrity. 4. Example. Broker manipulating client accounts may lose registration. Additional important points. 1. FUTP regulations are broadly interpreted by SEBI and SAT Securities Appellate Tribunal. 2. Mens rea intention is not always necessary. Even negligent misrepresentation can attract penalty. 3. SEBI can freeze accounts, issue cease and desist orders, and disgorge illegal gains. 4. Judicial precedents. Keaton-Perec vs. SEBI 2006. Circular trading equals manipulation. Ricksheet Securities vs. SEBI. Delay in disclosure equals unfair practice. 5. FUTP regulations work alongside insider trading regulations, covering public domain misbehavior. Role of Company Secretary. 1. Must ensure fair disclosure and ethical dealing by company and insiders. 2. Advise management against practices that may distort share prices. 3. Maintain records of price-sensitive information, investor communications, and SEBI filings. 4. Act as liaison officer with SEBI during any investigation. 5. Promote corporate governance and investor protection. Exam tip. Expect case-based questions such as ABC Limited. Manipulate stock prices through circular trading. Identify the regulation violated and explain SEBI's powers. Right finger always mention Regulation 3 and 4, intent of manipulation, and possible SEBI actions under Regulation 10. 12. Lesson 15.